Good morning. Uh, at the sidelines of Lex Infinitum, international event where the competition of mediation is going on at Salgaocar College of Law, we have gathered here to talk about something very interesting and important, again related to mediation. This is the topic. We call it as mediation musings, and this is part and parcel of our Lex Infinitum tradition. And I must mention here that this is our 10th year of Lex Infinitum, and we are actually proud of our own achievement, and it's all continuous efforts from the students that it's been made possible. Today in this mediation musings we are going to talk about one interesting topic, and I want your opinion on that. I know there would be definitely conflict of interest here because the topic name is conflicting, because mediation, a career worth pursuing, question mark, and I am asking this question to mediators. So let's hope we get an honest answer on these things, and I don't want to paint a rosy picture about these things. So let me give a little bit background about this whole event. Yesterday, myself, Ramrai, Prashant, and Professor Ranjana, we came for a recce because we wanted to choose a nice place to sit and talk. And we walked a distance of 3 to 4 kilometers, went on shortlisted of the places, and finally we zeroed on to this place. I hope you liked it, because background we see Race Mogos Fort, historical place, Mandovi River, as well as the other side of the river is Betim, and here we are in Panjim near Sports Authority of Goa and Youth Hostel. So this is how we zeroed down to this place, and to start with this whole thing, it's very important for the audience to know whom they are listening to. So my first question would be, I want you all to introduce yourself, and your introduction should contain 3 parts, preferably. First one would be you have to talk about your education, and then career choice, and why you chose this career, what made you to choose this career. So little bit of insights about your own life. We'll start, being a gentleman, we'll ask lady to start. Is it okay?
Yeah.
Yes,
Thank
Prachi.
you. So I started as a litigator in New York. My education includes going to St. Stephen's College in India, and then Faculty of Law, and then NYU for my LLM. And then something switched in my litigation career, in the sense that I got exposed to the concept of mediations. There were pro bono cases which would come in, and these pro bono cases would be a lot more satisfying than my regular litigation practice, because you see, for a big litigation in a white shoe firm, it takes a few years to come to a conclusion in a case, and it impacts a company in a very philosophical or a financial way, but it does not impact lives per se. So my switch was initially to personal mediations, and I went to Harvard after that to specialize in complex dispute resolutions. So that's how my switch happened, and I moved to India in 2010 because I realized that the mediation in this country is still lagging behind, and something that we could work on collectively with other people. And since 2010 I've been here working on mediations, and it has been a very fulfilling journey.
Yes, you didn't introduce us. She's Prachi Mehta, so only one part was missing, rest all she covered. Very nice. Prachi, you said that you got an exposure to mediation. Can you just give us incident that led to this exposure?
So there was the case which actually introduced me to mediation was a negotiation with the city council for the rights of a girl who was an orphan, and she had special education rights from New York City, which had been withdrawn because she could no longer prove that she needed special education.
So and she was specially abled, so she needed,
and she had no parents. She was living with her grandparents, only single grandparent, grandmother, and the city had withdrawn the rights, so we had been sent to a mediation to see if we could get her rights back. And from there on, I worked with some convicts to get some of their rights back. And that's how my mediation career started. Went on to, of course, dwell on the commercial side. And
You said it is very satisfying. How it is
Yes.
different from litigation satisfaction and mediation satisfaction?
so litigation is definitely a win and lose. And in any common law country, you actually don't know which side is going to win or lose. As a lawyer, when somebody comes to me or when somebody comes to anyone, we promise them the moon. But in reality, we can't deliver the moon.
Hmm.
And in reality is that you don't know which side you're going to end on. Sometimes it can depend on precedents, which we would like to believe, but sometimes it can also depend on the mood of the judge, what he ate for breakfast, or how things were at his home or with his own perception of the situation. A lot of these rights you would see in situations like homosexuality right in India, for instance. We've all seen the waves it's gone through, not just in India, all around the world. So these obviously show prejudices from authorities and from judges and from public at large. So mediation sort of calms those aspects down in the room rather than heighten them.
Yeah. Thank you, Prachi. Now I'll ask Claude to introduce to the audience.
I'm not a legal person. I'm a registered architect and a financier. I never practiced as an architect because I fell in love with hotels when I was in architectural school. Therefore, I worked for investors and I built hotels throughout the world. I operated many of these hotels. And actually, the case that was played in the preliminary round this morning was a real case that took 7 years of my life and that ended up in a mediation, which became, to me, the obvious way to resolve commercial business disputes. So after we settled that case, which took us a lot of efforts in 13 international jurisdictions and millions of dollars in legal fees, I immediately went to Gary Friedman in San Francisco and got my first mediation training. I then went to the Harvard program on negotiation for the negotiation class and the advanced negotiation class. And I pursued both careers parallelly between 2000 and 2023. And in 2023, I gave up hotel construction and management and became a full-time mediator. To date, I have carried more than 1,200 mediations, and I do about 100 a year.
In how many years? 1,200 mediations?
In 20 years.
Okay.
But now it's about 100 a year, mainly France and Europe. But I'm building also an international setup, by the way, together with Prachi.
Oh yeah, nice. Okay.
And indeed, mediation is, and I'm sorry for the legal community, the only way to settle business disputes. Because it's never about the contract. It's never about the law. It's most of the time a problem between two egos that have stopped talking together. And the role of the mediator is to make them talk again and be intelligent for a change.
So you actually were an architect by profession, and you are in a field which is dominated by lawyers.
No, dominated by architects.
No, you may be dominating, but number-wise, there may be more lawyers around. How you are preferred? I'm talking about the client.
Oh, you're
perception.
talking mediation. I thought you were talking construction.
No,
Sorry.
no. Mediation. So, if you look at a client, he may prefer a lawyer as a mediator over a non-lawyer. But how this works?
I think I've been asked that question continuously for the past 25 years.
I thought it was innovative
Does
question.
the
It's not.
mediator need to be a specialist or not? And there are two answers to that. And in fact, there are three answers. The usual two answers are the parties prefer somebody who knows the business.
Okay.
The mediator prefers not to know the business because he asks the question that nobody has asked before. And that's where the dispute lies. So for a while, I was considered a construction and real estate specialist. So they would send me construction and real estate disputes. The problem I had is that I understood the case better than them, but could not put it on the table until they have realized where they were going. And after 25 years of disputing with myself, I found the answer. The answer is that in 25 years, I became a resolution specialist, regardless of the matter. Let me give you an example.
Yeah.
Construction disputes are roughly 50% of worldwide litigation. Most of the time it happens with something that is not in the contract, that is not in the specification, that is not in the plans. But lawyers are gifted. They find a way to take it to court.
Yeah.
Tell me, who, from the painter or the carpenter, has to do the skirting or the paint first? It is not in the contract, but it can stop your construction site for 6 months or 1 year.
Oh.
If you take it to court, it's 5 years.
Yeah.
If you go to mediation, you will find out that the carpenter and the painter do not like each other, but you will find a way. The carpenter will do the 5th floor and the painter will do the 4th floor.
Yeah.
As easy as that.
As easy as that. Thank you very much. Prachi and Claude, successfully we kept hardcore litigator quiet for this long. Now I ask Mendes, Professor Mr. Mendes, can you speak about your education, incidents, etc.?
First thing first is I'm an alumni of VMSCL. So that's my home college. But before I joined college, I'm in the practice for over now 37 years in this practice. But before I started practice, I was a trade union leader in the ports. We had about 4,500 employees under me. I was the vice president, and we had disputes day in and day out. Conflicts between the employer, conflicts between the employees themselves. We opened up cooperative thrift societies, so we used to loan them, they used to fail in paying the loans, so we had disputes working intra-se within the organization ourselves. Once I completed my master's in law, I quit from the port and I came into practice.
Okay.
When I came into practice, because I had a background of shipping, the work that gravitated to me was maritime disputes. And people who know maritime disputes will understand that one of the first issues that come to court is the question of jurisdiction. And which place has it, and which ship to be arrested, and how much, and the captain wants to go, so time was a major factor. And litigation wasn't providing any answers there. Litigation, of course, has been the backbone of my revenue, which it continues till today as far as India is concerned, because we have yet to come to a stage where commercial world accepts mediation as the forefront of dispute resolution. But coming to my, let us say, fascination with the current mediation that we are in, it all happened because I had gone for an arbitration to the ICC in Paris. And when I was there in the ICC in Paris, they asked me, are you familiar with mediation? And I said, no, we have, at that time the Arbitration Conciliation Act did not exist, but we had conciliation in the Industrial Disputes
Yes,
Act.
we had, yeah.
So I told them, I'm familiar with that. So they told me that ICC has just completed its first year of a new competition. Why don't you come in the second year? So I joined the ICC competition in the second year, and now it's over 20 years. And that's how I got into this concept of converting the concept from conciliation to mediation. And from then, I had been advocating mediation the length and breadth of India, pushing it through, getting reluctant parties to consider mediation as a whole. And today, India has a Mediation Act.
Yes.
So hopefully, the business houses, students are being trained as mediators. Judges are being trained as mediators. Some lawyers are being trained as mediators. We need business to begin to realize that here is another solution that's available for them. So that's my passion that drives
Yeah.
mediation.
Thank you very much. As we know the panel now, actually I'll just lay down the scope of our discussion. So today we are going to talk about the concept of mediation for the beginners who plan to venture into the mediation as a career option. So the task before you is to keep the language simple, because by now most of the audience must have been scared to listen to you, because you are, one is architect, other one is human right activist, and now we have a trade union leader. So accidentally we have gathered the wide breadth of this whole panoramic area of law. So but we have to keep this in mind. This we have designed it for the beginner. We have no control who is going to listen to us, but first we want to deal with the concept of mediation. Then we have to understand the mediation as a theory and as a practice, because you are all practitioners and who have practiced mediation. And finally you have to guide the youngsters as a career, mediation as a career option. So I would be interested in knowing that how one can carve a career in a mediation area. And another interesting point which I want from you all is that in what way you can help an youngster in carving a path for himself. So that we will come to that at the later stage. But now let me start with the toughest task of it. Can you put the idea of mediation in a simplest of form for the benefit of children? I'll start with Mendes.
Mediation is simply getting two people who have difficulty to speak of things behind by using a neutral third person. This is about all that mediation does. Mediation has nothing to do with settlement, which is a misconception outside. Mediation has nothing to do with costs, which is another wrong thing that the litigators we put on that side to give it a bad name. Mediation is all about conflict between two or more people and their inability to communicate about that conflict. And the role of the mediator is to help them communicate. If they are able to communicate satisfactorily and remove the conflict, they may not be friends, but they are definitely not enemies, and they will work to a common goal. That's the object of mediation.
Thank you very much. You really simplified it. Now the task becomes a little tougher for you, Claude.
Much tougher.
Yeah.
In one of my advanced training, I had my two favorite teachers, Gary Friedman and Bob Menukin, and they asked me, what is a successful mediation? And I said, it's a mediation that ends with an agreement. And then they started charging at me. Is that what we have taught you? A successful mediation is, and that's exactly what Ethelwald said, is when you have achieved for these two people who were not talking for the past 5 years to talk together. They know their business better than you will ever know it. They know where the solution is. They only need you to find it. So allowing them to speak again, allowing them to think together again is mediation.
Okay, that's interesting. Prachi, you want to add something to that?
I think everything has been said, but to me, combat is the form of litigation. And
Yes.
to me, being able to talk to each other is a form of resolution approach. And we are going to have conflict in every situation. Whether we have conflict at home, whether we have conflict at work, whether we have conflict between two countries or two companies. The way to resolve it forward is to mediate.
Yeah.
You will not be able to get a resolution, you will get a verdict if you
Yes.
go to the court. And a verdict is never a preferable form, because a verdict can be incomplete, a verdict can be against you. And even if you have won in the verdict, the amount of time, the amount of energy and the amount of emotion you lose over it sometimes is taxing enough for the winning verdict to not be
Yeah.
worth it.
If
So-
I may add something,
Please.
any discussion between two people or more is a negotiation.
Okay.
Mediation is a negotiation assisted by a third neutral. That's probably the simplest way to put it.
Okay, now this raises a lot of doubts in my mind, but I may
Very
be
sorry.
actually, I was supposed to clarify. Yeah, please come. Please come. Yeah.
Thank you
Thank
very
you.
much.
Thank you.
There's nothing like chai.
So, you have just broken down a myth which is built around mediation, that it is in the domain of a lawyer. A law practitioner is more suited for the process. But when I listen to all three of you, it looks like a more of a domain of a good man, a good person, a person who can bring people together, make them talk to one another. Because as Claude mentioned, they know better than their field of practice, and we are only facilitating the talking between them. But I'll come to that discussion at another stage, a later stage. But now, as Ethwal started saying that conflict is the reason, and resolving the conflict is the role of mediation. Now, when you look into the conflict, now the world is changing so fast, and earlier the nature of the conflict was different, and now what is the impact of modernization on the nature of conflict?
If you want me to go first, conflict remains the same, the dimensions change. So the word conflict simply means that a person is unable to accept a certain position. That's a conflict. You can have a conflict with yourself. You can have a conflict with somebody else.
Yeah.
It's all about positions. In the modern era today, you can have a conflict with signals not coming and your whole performance not working. As a result, you would sue the service provider.
Yeah.
So you see, conflict doesn't alter the concept of person. The manner in which we approach it and the nature of the conflict may change from time to time or person to person, or what we now talk about today in cross-border. Both are talking the same, but you're speaking Chinese and I'm speaking English.
Yeah.
We both can't understand each other despite the fact that we are not at loggerheads with each other. So
Yeah.
this is
But now, when you talk about this conflict, Mr. Claude, the word conflict and the word compromise, because I hope you will agree with me that mediation is nothing but a process to come to a compromise.
no.
No,
That's absolutely wrong.
Absolutely.
absolutely not.
Okay, then I have to reframe my question. Because that's what generally everybody's think, that when you mediate, you compromise and you come to a settlement.
Let me
How
bust
can you
that
come
myth.
to a settlement without compromise?
Now let me bust that myth. Mediation has nothing to do with compromise, nothing to do with bargain. Mediation is negotiating about one's needs. There may be an element of a compromise in the stance taken by one person or the demand taken by one person, but
Yeah.
that's not the objective. The objective is addressing and satisfying the needs. And if my need is satisfied 100%, then there is no compromise. There's no bargain. I've got the whole.
That means you are winning.
It's a win-win situation on both sides because both get what they want, not what you plead in case. See, in court we plead $100 million, but that's not my need.
Exactly what I said, that the lawyer will promise you the moon.
Yeah.
But what is your reality is what is your reality.
And I tell you this from a background of trade unionism.
Yeah.
We know that if we want to get something, we make a charter of demands of 100 items, knowing fully well that we need only 10.
10.
And we can tell the other side, look, I'm ready to give up 90 if you give me the 10. Now, what do you call this? Bargain, compromise? Nothing. I've got my 100%.
Mediation is not in our usual world. It is outside. One thing that Edevald has forgotten is also risk assessment. In court, you will not take into consideration your attitude vis-à-vis risk, nor my attitude vis-à-vis risk. That's probably where we can find some common ground. But let's look at something very simple. There's 100 rupee note on the table. You want it, I want it.
Yeah.
The usual way of looking at it is that you will go with 50, I will go with 50, or you'll go with 60, I'll go with 40. That is compromising.
Correct.
Mediation is asking the two people, how can we make that 100 rupee note worth 200 so that you live with 100 and I live with 100? That will not happen in court. That will not happen in conflict. The only place where it can happen is in mediation, because we will bring these two people to think together, be creative, and, as they say at Harvard, enlarge the pie.
Yes. So
Make the pie bigger.
yes, make the pie bigger is the motto of mediation process. So now, when I look at the panelists, you are human rights area, you work on a construction, you work on trade union. There are different genre of disputes. Whether your tactics as a mediator change with the genre. Prachi,
So I want to first address two things that you said earlier. Oh, by the way, I'm not a human rights mediator.
But you worked
I
on
started
disability,
with-
yeah,
started
yeah, yeah,
with
sorry,
that.
yeah.
I do actually commercial and personal mediations now. So I want to debunk two myths. One, you said that what is conflict in the modern day?
Yeah.
Going back to that. So for us as a world, it has changed tremendously. When we thought of conflict, say 50 years ago, we thought of a very hierarchical structure. A negotiation had a very negative connotation to it. For instance, a negotiation was kept aside with a idea of bringing in negativity into a conversation, and the top tiers had the right to make the decisions and the bottom tiers had the right to follow the decisions. To give you a very simple example in the Indian context, somebody who's younger or junior in office would follow orders,
Yes.
right? With the advent of the internet, that system has changed. We have now become flatter. I might be sitting in America, but my Amazon customer care service might be sitting in India or China, right? Now we are negotiating continuously 24/7 in a flat structure, where we are not taking information or directions from XYZ who's above us. A customer care service representative, for instance, has the right to give you the refund in case it's required from your side for the fault of a third person.
Yeah.
So the way a conflict happens has changed in our modern world. The nature of conflict has changed to that limit that the negotiation tactics have changed. And we now no longer hold negotiation in a negative connotation. In fact, if anything, negotiation has become a subject which is taught widely in law schools, in management schools, in life skills.
Yeah.
You know, it has become a part of our life skills. So to that perspective, it has changed. When you say the other thing, when you said that how do you compromise? So the reason why a lot of Indians believe that it is a compromise is because we see a lot more post-litigation mediation in this country versus pre-litigation mediation.
Yeah.
Now in post-litigation mediation, you have already gone loggerheads in the courtroom. And that is one reason why conflict situation as we see it in this country is very different from pre-litigation mediations which are happening around the world. So that's my take on how conflict has evolved over the years and how in particularly the Indian context it's very different. If I have a client who I am working for within US who is doing, say for instance, a pre-litigation mediation, the way the conversation goes, even if an Indian company is involved, is very different from the way the conversation would go in a post-litigation mediation. Because there you have to go back to the courtroom with a compromise. And in that structure, we are sort of deviating from the way a pure mediation should work. So my hope is that with the advent of and coming in of the Mediation Act at some point, as a country, we would also see a surge in pre-litigation mediation, which will again change how we view conflict and how we view mediation in the.
Yeah. So just to stand myself clear from the accusation that you just made, and I said compromise. I think you clarified, and I got an idea when you're saying about pre-litigation and post-litigation. The lawyers promise moon,
Yes.
and the client start believing that he's going to get the moon. And when you go for a mediation, the client would be disappointed because he's not going to get the moon. So now, how do you as a mediator educate the client that
Let me come to that first for myself, because this happens to me every day. I'm a lawyer. I get clients telling me, "Sir, we took you because you are one of the best lawyers. People are scared about you. Why are you asking me to compromise?" I said, "I didn't ask you to compromise. I asked you mediation." But that's compromise, no? See, the mind of the set of the people. That's why I jumped in to tell you mediation has nothing to do with compromise. Because the mindset that has been given to people is that mediation means you have to compromise. I have to give up something. I have to lose something. So while we call it win-win, they say I've lost. So then I have to tell the people that, look, think of it that this is another option that's available to you. If we can convince the other side to get what you want, the matter is over. If you don't, I'm still your lawyer. We'll continue. I'm still your good lawyer. Don't get scared. But you don't have to give up anything. Here you get a chance to tell them what you did is wrong. This is what I need. Can I get it?
I fully concur, and I would like to add another way to look at it. It's also some kind of a lack of education. Professor Fisher from Harvard and William Murray wrote a book which is very well known, which is called Getting to Yes.
getting to yes?
That was 40 years ago.
Yeah.
Very few people have read it. And knowing the negotiation Harvard style is an opening of your mind. It's not about compromises anymore. It's really about win-win, looking at things differently. And I notice, being a French, that French lawyers are not yet at that stage. And I use them to train their parties before the mediation session to prepare for that negotiation meeting, because it is a negotiation meeting, and to prepare the negotiation as it has been taught by getting to yes. What are your alternatives? What are your interests? What are your options? What are the standards? What is the legitimacy? How do you want your relationship with them? Prepare all of that and understand what they want on the other side of the table. Role play. What does he want? What do I need? How can we have this coincide and not compromise?
So that means when I raised this issue that my question was regarding educating the client about realistic approach towards the problem rather than the flamboyant
Constructive approach. Constructive approach.
constructive approach. Because as Prachi said, already moon has been promised. Now how do you bring him down from that expectation to reality as a mediator?
How do you deliver?
How do you do that?
I would say that we are placing too much of burden on the mediator. We need to understand that in a mediation room, there are 5 people sitting in that room, of which one is the mediator.
One is mediator.
2 are lawyers or counsels, and 2 are disputants. It's difficult to expect disputants to understand this process.
Yeah.
But definitely the other 2 legal professionals, they are the ones that need to learn. They should learn something known as the ZOPA, Zone of Possible Agreement. They should learn something about the BATNA, Best Alternative, the VATNA, the Worst Alternative. These are things and skills that these legal professionals who otherwise think of litigation as their domain for dispute resolution have to learn these skills.
So you mean to say that sitting with the lawyers before actually meeting the clients and discuss it out would be a good strategy, so that you can flush out all the
Say good strategy, I say that this is what requires to be done today, because they are not up to standard.
Okay. Actually, they should have done the homework and come.
Yes.
But now the necessity is that they are not doing it. So the mediator. Yeah. So let us move on to the next component about factual check, because there is one it's Professor Greg Bond. He used to tell that mediation is just all talk and no action. And so I want to know about different legal system, how it works. Can you please speak about American system? And sir, which one you would be speaking on, French or?
I don't know anything about law.
Okay, but you will be knowing about the conflicts.
I know about conflict, but I don't know about law, and I don't care about law.
Indian.
India and the surrounding
areas. Surrounding areas. So the question is this: mediation, all talk, no action, means everybody talk about mediation, encourage the people to go for mediation, but nobody does mediation.
That's true.
So, as Mr. Mendes mentioned, his bread and butter is litigation, even today, after 37 years. And maybe last 20 years he's been spreading the information about mediation all over India. But still litigation is his bread and butter. So, how is it in USA? How far the mediators do well? As far as professionally concerned, they earn well.
Yeah, well, it depends from state to state, and also how states perceive mediation as a mechanism. So in US you have federal structure and you have the state structure, right? So there are some states which are doing exponentially well in that. In the Indian context, I would take 2 minutes of Sir's time in this. I think the problem is not with educating the people. The problem is that we have not made structures which require pre-litigation mediation.
Okay.
And once those structures are made, and there is some sort of a downfall which you witness because of you not following a sort of a pattern to resolve a conflict, those structures are what will enable us to move away from litigation and actually make mediation a full-time practice. And until those structures are in place, every person will have to fend for themselves for bread and butter through other professions, whether it is being a lawyer, whether it is being an architecture. And when I practice in India, I still do litigation. And the primary reason for that is what Sir said, that you cannot get a case in mediation unless and until you are actually working as a litigator. So my aim in litigation is to try and onboard cases which I can take towards mediation rather than towards litigation. And you can see that as a lawyer very quickly into the matter. Now this is how both the structures work. But in an architect's world, I am not sure.
How about the payment? Do mediators do a lot of money? They make a lot of money?
It depends. So it totally depends on what your caliber is and what kind of a case you're looking at. I do pro bono mediations for some organizations where I'm working for developing community mediation on grassroots levels in the country to take to tier 2, tier 3, even villages in remote areas. I also do pro bono mediations for some of the government organizations. I'm on the panel of the Supreme Court Mediators. These are not well paid things, but we still spend our time on it because we know that the end result for the country as a whole will be great. There are private mediations which we do, which are very well paid. There is no problem in payments in those. So there are both aspects to a coin. Just like as a lawyer, I would think another aspect which our law is missing is mandated pro bono work for a lawyer. So because when we don't have our lawyers trained like that, we don't know as a lawyer that we can do things apart from just making money in our profession, right? So in US you have mandated pro bono work as a lawyer, which you have to report along with the cases, along with the jurisdiction where you did them, which sort of you become answerable to the system. What are you giving back to society? So once you're doing things like that, you understand that there'll be paid aspects and there'll be unpaid aspects. Just like a doctor sees some patients free of
Yeah,
cost.
that's true. That's true. That I agree.
Yeah. So payment is not an
yeah.
issue at the end of the day.
See, this question is designed because youngsters are going to watch this and they have to decide. You have done 1,200 mediations. So my question is, how many houses you own now? How many houses you own now? You must have
many?
made a lot of money.
Houses.
Oh, I'm thinking about buying a house in Goa.
We did the maths today.
But to
morning.
answer
Oh yeah.
to answer your question about jurisdiction, the British have implemented something 10 or 15 years ago, which was a mandatory mediation prior going to court. France and Europe have followed suit, and the previous Minister of Justice in France went very sharply with amicable settlement, and now France is on the way of developing
Okay.
alternative dispute resolution, mainly mediation. And that also takes part at the European Parliament. So there is a will
This is 10 years old story
in England,
in England. Okay.
in France 2-3 years.
2-3.
However, two judges in France started to send cases from the court to mediation some 13-14 years ago. People were not happy with that
Okay.
until these two judges show their statistics. And their statistics showed that they had agreement, that they had meetings, and that's what interests us, in 97% of the cases. And meeting is a success for the mediator. They had agreement in 75% of the cases. The duration from the start until the finish was in average 89 days, and the cost was below 2,000 euros. So 2,000 euros is roughly 2 lakh rupees.
Yeah.
So there is a push, and slowly we see that the lawyers understand that their real job are to be counsel, not litigators, because the solution that, and we said that already, the solution that comes out of mediation is much better
Much better.
than the judgment that they may have. You know, in France we have a famous writer, Honoré de Balzac, who said, a bad settlement is better than a good lawsuit. My motto is that a good settlement is better than a bad lawsuit.
Yeah.
Because nobody knows about a good lawsuit.
Nobody knows. Yeah.
Now, when one talks in terms of India context, we have been pushing mediation as the cheap alternative. Less cost, less this. Now, when you say cheap alternative, you must understand where does the cost cutting take place. First cost cutting take place is legal costs.
Correct.
So that means the lawyers' remuneration gets reduced, and that's the basic opposition from lawyers. Two, as Claude says, even in Paris, even in India also, the whole cost of mediation, if you are going to put it at 2,000 euros, then definitely the lawyers or the mediator's fee is far below that,
Yes, yes, definitely.
vis-a-vis arbitration and litigation. So this is why I said mediation as cost cutting should not be our USP.
Okay.
And I'll tell you a little while because I'll discuss this. Two, as far as mediation is concerned, see, we have disputes that have no monetary value, they have emotional values in family disputes. Cost-wise are a little less, but the work is high, the
Yeah.
emotions run high. The other ones are community issues, discipline within that, law and order problem, XY. The ones that have money is the commercial. And unfortunately, the commercial world has not yet in India come to terms with mediation. And for a good, let me give you an example of a matter that was settled by me in a matter which was a joint venture concern between the Chinese organization and an Indian organization in the deep sea fishing industry. We filed a suit, we used some tactics to get the leverage, and we ultimately got the parties on the table for a negotiation. The amount was settled for a good amount of about 14 million US dollars, and I'm talking about 20 years back, paid in the Mauritius. My fees at that time for appearance was 500 rupees per sitting. So the case got over in 2 sittings. I didn't expect more than 1,000 rupees. That's all my hearings were. So therefore, vis-a-vis a case that would go on for so long. So after it got over, my clients, who are quite well established, famous clients from India, they came down to my house one evening with a huge bag like this, and they asked me to give me a tray, a serving tray, and I took out a serving tray and I gave it to them. I'm wondering what the hell was it. So they took it, they went to a corner, and they covered the serving tray with a lot of fruits, different type of fruits, and they offered it to me as a thank you for having done this fantastic job. And I said, okay, and I said to myself, what the hell, they're giving me fruits. I've lost money for the case. And they said, thank you, we said, okay, and we went off. After they left, when I took out the fruits, there was 20,000 rupees there as their gift for having resolved such a huge matter in so quickly.
Yeah.
So that is what message that I want to give to the youngsters. That if you are able to solve matters to the satisfaction, especially financially, of the clients will not forget you. Now, having said that, 3 years back, we had an E&W conference in Delhi. Shriram Panchu was one of the main speakers. Shriram Panchu, incidentally, is one of the largest names of mediation in India.
Yeah.
He's got 2 books, which I hope your students will read.
Yeah.
But he said that something very important, because this is what we were discussing earlier. We send students to the best colleges by spending a fortune. And you expect them, after passing out, to come and do mediation for what? Pro bono work. Their parents are going to say, I spent a fortune to teach you. To do what? Charity. So unless we make mediation a lucrative perspective, and I don't talk in terms of arbitration, but at least a reasonable one, you won't get the good talent from youngsters coming into us.
Yes, that's the reason arbitration picked up much faster than mediation.
Yes, because of the lure of money.
Let me add one thing that I discovered recently. We all talk about the cost of litigation, the cost of the lawyers, the time we spend, but we forgot the biggest element, the cost of opportunity. Let's say that I have a hotel project in Goa, and I have a fight with the port of Goa, and I go to the bank and I ask for a loan to build my hotel. What will the banker's reply be? Settle your dispute and come back later. In the meantime, the land is gone and I lost my opportunity. We're talking 10 million. In the US, where mediation is practiced commonly because going to court costs a fortune, a mediator like us makes 10 times what I do in France. And no question, France and the US are about the same cost of life.
Yeah.
Why is it that the guy who has my expertise in US makes 10 times more money than I do? Because of recognition.
Yeah.
What you just said.
So here, Prachi has raised one issue which is actually interesting to me. She's talked about having a structure, and once you bring the structure, then the mediation will progress, and it's going to become part and parcel of dispute resolution system. What is the structure that is there in Europe? And we have Mediation Act 2023. If you had an opportunity to go through it, the structure that is proposed there, how far that is going to address our requirement? Should I ask about US, UK first? The structure that exists in Europe.
Mandatory, whether it's mandatory.
Well, it's very simple. You have to check a box
Okay.
before you file your document saying that both parties have considered amicable negotiation. It is now the same in France, except that they have made mediation mandatory for case below 5,000 euros.
And to be a mediator, there is any institution that recognizes, conducts the test?
So that's a very complicated issue. Finally, we have some wording both in France and in Europe that say that to be a mediator, you need to do a training
Mhm.
There are differences on the number of hours, country per country. It goes from 60 hours to 100 feet to 250 hours. You need to adhere to a code of conduct or code of deontology, and you need to have a personal liability insurance.
Oh,
In France, what they have implemented is if you want to have cases sent by the court, you have to be listed by the Court of Appeal like the experts. But the thing is, they've done it in such a way that in Paris, you have probably 2,000 mediators listed at the Court of Appeal, where the Court of Appeal doesn't do more than 200 or 300 mediation per year.
per year.
So you have more mediators than mediations.
Mediation. And in case of misconduct and other thing, is there any institution which does any disciplinary action against the mediator?
Not yet, not officially, except that since 2007, several mediation organizations have put together an institution which is called the IMI, International Mediation Institute, which is the only one in the world that grants certification to mediators. And they have a misconduct process in their bylaws.
You mentioned about liability insurance. Why that? What kind of liability you may run into?
If you're a lawyer mediator, you do have a liability insurance being a lawyer. If you're like me, a mediator, I may have a liability insurance as far as architectural work is concerned. I don't have a liability insurance. Now, I understand what's below your question. What kind of liability has the mediator?
So you are not deciding anything?
Yes, but you cannot prevent a party to be mad at you because they didn't find a solution. Or, in a more realistic way, let's say you as a mediator, you breach confidentiality.
Oh.
Then you have a liability.
Yes, yes.
Because confidentiality is the basis of mediation. We can tell each other what we cannot tell elsewhere. We can tell each other what our counsel cannot write in their conclusions. And it's because of confidentiality that there is an agreement 75% of the time. Because we can say what we cannot say elsewhere. I can explain to you why I betrayed you, and maybe you will understand. And then the conversation will resume and we'll get to an agreement. But if I don't tell you why I've betrayed you, you'll be mad at me for the rest of your life.
Yes.
How can you resume confidence if we don't talk to each other? And how can we talk to each other if we are not sure it will not get outside the womb?
And about, have you gone through the act? Did you had an opportunity?
So the act is a little, it will, like the Arbitration Act, have to go through certain rounds of amendments at some point, because the structure that they have tried implementing in the act does not mandate pre-litigation mediation in a very structured manner. So there will be loopholes in that area, and just like in France, it will be a tick box. Now in India, let me give you an example. So courts have mandated, at least in certain jurisdictions, mediation for family law matters, right? But courts are sending these matters for mediation after they have come to the court. We have already spent 1 day on them. We have already spent a lawyer's fees for filing a divorce petition, a reply, and then go into mediation, and then spend another few weeks in mediation in a system where it is not necessarily designed to succeed, right? The way the court mediations are structured, you are still in the court premises, you still feel the pressure of being in a courtroom, right? The person who's walking in as a mediator also is wearing a gown, and so are your lawyers. So we have not built a structure per se for making the parties feel that they are going through a voluntary process. And most of the times when I'm sitting in a court mediation, the parties actually walk in and say, please tell us what to do. And you tell us, you write it and we'll sign it. You know, sometimes they are that inefficient. So We have, our cost of litigation is not as high as US. It does not affect us as much. Also, arbitration has seen a very high surge because there is a lot of retired judges, retired professionals who are involved in it. Mediation has not seen a surge as yet of such people getting involved in. And the minute that involvement increases, the minute that time is consumed from people like this, we will also see a similar surge. Unfortunately, the new Mediation Act, I still feel, has a little bit of a lopsided idea with respect to mandating mediations before going to the court.
But as far as training is concerned and liability, accountability, we have a structure as of now.
We have a
Now,
structure.
let me come down first to the Act. The Act came into force in December 2023.
Yes, yes.
The Mediation Council, which is supposed to manage it, is somewhere in the grey area, which will come out now.
Oh, it's on the way.
It's on the way. It's going to come out now. Having said this, the Commercial Courts Act,
Yes.
Section 12A, has a mandatory pre-litigation mediation clause. So you can't file a suit unless you get a certificate from the District Legal Services Authorities Act, which is supposed to do pre-litigation mediation, gives you a failure certificate.
Yeah.
So this is one of the elements. Having said that, the Supreme Court has in two judgments held that Section 12A of the Commercial Courts Act is mandatory. But they have also held that 12A has an exception if the plaintiff contemplates, the word is contemplates, that urgent reliefs are required. And the Supreme Court has held that the contemplation is purely of the plaintiff and nothing to do with the court. So whether the interim relief can be granted or will be granted is of no consequence. Suffice if he files an application for interim relief to bypass 12A. And the High Court, the Supreme Court also further says in that judgment that clever litigation and drafting is being done to circumvent 12A. But the Supreme Court said that is not for us to decide, that is for some other authority to decide. So this is the position that we have as pre-litigation mediation. Now, having said that, we have Section 89 of CPC amended
2002.
in 2002, which brings in 4 different types of ADR.
Yeah.
And the High Courts have then got rules, MCPC has also got rules. Now, today, under 89, after the pleadings are complete, the civil court is required to examine the parties first, reduce that in writing, and then see if there are elements of settlement, and then ask the parties to choose. This is something that does not happen because the judges don't even know that Section 89 has been amended, despite the fact that they have been appointed and selected for so many years. They are absolutely blank on this. So when we talk about the structure being there, that's where it's failing. That structure is not there. 2, if you look at the celebrated UK case, which we talk about mandatory mediation, which it has held that you can't make it mandatory, it should be voluntarily. But having said that, it's now the King's Court has come to the conclusion that if a party without justification refuses and is the plaintiff, he will not get costs. If he is the defendant, he will be saddled with costs for otherwise. Now this is something Indian courts also do not look at. If the Indian court looks at this concept of 35A of CPC, then recalcitrant or what we call contumacious litigants will come to track and prevent frivolous, unnecessary litigation. So this is what we require when Prachi said we need the structure. It exists, but it needs to be implemented. Now, having said that, in mediation, we have court annex mediation and we have out of court mediation. Out of court mediation is rare. It's just between 2 enlightened legal professional establishments that decide to do out of court. Otherwise, it doesn't happen. Most of the litigation, mediation in India is court annex mediation. That is where the court directs that mediation should take place. In that, we have two sets of mediator panels. One is judges trained as mediators and two lawyers trained as mediators. Minimum requirement for a lawyer is that he has to be 15 years in practice. Otherwise, he can't be trained as a mediator. Then, of course, the 40 hours and all those various things that are involved. Now, if a judge who is trained as a mediator is selected, there are no costs for the mediator. If the lawyer is appointed the mediator, the fees are 2,500 cap. If there is more than one matter or taken together, then the cap is 3,500 as a cap. Now, when you look at this like this, today lawyers, if they don't want mediation to succeed because it's going to lose their bread and butter, they will opt for mediation by the judges because there is no cost. And get a failure as fast as possible and run back to court. So again, so you see, there is a lopsided push to mediation.
Yes. So I understand the concerns that you are raising, because mediation has cultivated more dislikes from the professions and other things because of the way it's been pushed by the state.
It's a wrong push.
Wrong push that they have made. So now let us take to another interesting part of our discussion about mediation as a career. Now, if I am 20 years old and I am planning to join or get into mediation, what would you recommend? That what kind of skill set I should have so that I can choose mediation over litigation? I'll ask Prachi.
So at 20 years, you probably should not be a mediator. Let me start by saying that. You should actually get a feel more of either your profession or of the legal profession per se. What you can look at is mediation advocacy.
Okay.
And it is very important for us as a country and understand what mediation advocacy is. Once we understand that a lawyer can actually earn the same amount of fees that he earns in a litigation room, and how mediation advocacy actually works is the time that it will become a palatable option for young lawyers to take their matters to mediation. And actually settling a matter in mediation for them does not mean that it will finish the matters that are coming to them. Because if you settle one matter, it's going to take your name forward as a mediation advocate. I actually have to tell you this, that most of the senior lawyers, if they have a personal matter, or if their cousin has a matter, a sitting chairman of a law firm has a matter, they actually refer it to us for private mediation. They are not charging them because they can't charge them, you see. So
my cousin is an orthopedic. If I go with a problem, he'll give us exercises to do.
Yes.
He never does any scanning because we don't pay.
So exactly like that. So as a young student who's graduating, you should look into mediation advocacy. And at some point, slowly, once you have the hours and once you have the ability to understand how to run mediations, you can convert yourself to the side of mediation.
If you zero down to one skill, most important skill for a mediator, what would be that?
Patience.
Patience. You.
Well, I'm sorry for the students, but I think that in order to be a good mediator, business or commercial mediator, you need to have some experience.
Okay.
Whereas as a lawyer, as a business person, as a doctor, but understanding of what life is, what business is, what work relationship are. And I see it difficult for a student to become a mediator just out of school.
Okay.
And I think that the parties I have in mediation, they like me because I have a very wide experience, whether international or not only in construction, but in business, in debt raising, in financing. They can talk to me about things that I'm supposed not to know, but still I understand because of my experience. And that comes to the first quality of the mediator, active listening. But if you listen, it is to understand. If you don't understand, what's the use of listening? And to understand, you need some experience.
So it's active listening, and active listening for a long time. If you have an experience,
Yeah, because there
then
are
you
people who speak for a long time, yes.
patience. Sir, your take on that.
See, first thing you must understand that in a mediation, you are dealing with human beings.
Hmm.
You are not dealing with it. And it's emotions, it's behavior, it's pattern. You're not dealing with the law. You're not dealing with complex facts, who's right, who's wrong. You're dealing with human dynamics.
Hmm.
And this is the most important skill which you don't get in a law college.
Yeah.
How to deal with people, how to diffuse situation, because that's what an impasse is all about.
Hmm.
And most importantly, as Claude says, I echo this, you must have credibility. If you are raw and young, especially like in India, where we have the saying, don't teach your father to suck an egg.
Don't teach your father.
To suck an egg, because he's the one who knows. So therefore, the idea is that you are too young to tell us what to do.
What to do? Yeah. So gray hair plays an important role.
I wouldn't say grey hair because
Yeah, because I don't have any.
So let me
what you want to
supplement.
say, what you want is today is that you must have some background behind it
Yeah.
of maturity.
I'd like to add one thing that may look mundane,
Huh?
which now is very important to me. Gary Friedman told me 25 years ago, you should not have a table in your mediation room.
You should not have
A table.
table.
Took me 25 years to listen, 23 years to listen to him. I've taken away the table in my mediation room. My mediation go much faster and much easier, and that goes back to what Etewald said about you have human beings. There's no barrier
Barrier.
in between themselves. And the first time I did it with a lot of care. I was a bit frightened. And 5 people entered the room, 3 and 2, and they were surprised. There's no table. And I told them blank. I said, no, that's a test. We have taken the table away. You know, in France, we are more formal than the American.
Oh.
We call each other Mr. So-and-so. We don't call by first name. 10 minutes into the mediation, they were calling each other by their first name. Magic. Why? Human beings.
Human being. So this is a subconscious barrier. We don't realize.
It's not subconscious. It is fully conscious. Same thing. If you put a table, what are they going to do? They're going to pull their file out of their briefcase. They're going to open their laptop and hide behind the screen. They cannot do it. There's nothing here. They don't know if they should do this or this.
So to supplement that, when I started mediating in India, I was still fairly young. And I was told by a very senior mediator, you must put on more makeup and wear a sari and dress your part, because otherwise you're not going to be able to convince people.
If you're dressed in t-shirt and jeans.
Yes,
Jeans.
no, not just that. I mean, for them it's a particular style, right? See, I was here coming from US, and US is a lot informal, as Claude said. So when I would walk into a mediation room as a mediator, even in my early 30s, they would look at my credentials. They would look at my experience as a litigator, both New York and California. They would look at the fact that I had mediated with some of the largest organizations in the world. Here, it was the opposite. They would look at how I was dressed. So I had to play the part, and it's a cultural difference. There's nothing wrong with it, right? There's nothing wrong with it. So for a student right out of law school, you have to develop that maturity to understand. And once you've developed it, look your part and go for it.
So there would be a surge in mediation on a right age once you reach the right age.
No,
Once you reach the right experience.
Right experience.
No, there will be surge in mediators. We are not talking
Mediators. Yeah, surge.
We have been saying that you can do mediation advocacy right off the bat. And this is what I have a training institute where we train mediation advocates right off the mark, and unless they have done not less than 5 mediations, as a mediation advocate, I don't take them to learn as mediators because they haven't seen what happens.
Yes, yes. So now we have one terminology we use, a well-read advocate. Can that terminology be applied to mediator, well-read mediator? Are there a lot of literature available on this so that you read a lot and you become an excellent mediator? Claude.
There are plenty of books, but there are plenty of books not about mediation that the mediator should read. Getting to Yes is the first one. Beyond Reason is another one. Books about mediation, yes, you should read plenty of them. But the problem is, I teach mediation. And when I teach the practical side of mediation, not theoretical. And every single time I teach practical mediation, I have one student in the room that said, well, what you just explained is great, but it's completely the opposite of what we learned.
Oh, yeah.
And I look at them with a big smile and I say, 25 years ago I learned the same thing as you did. But today I'm 25 years later, I have developed my own style. And my own style I won't find in a book. I will find in my experience, in my practice, in my talking to myself in the mirror and debriefing what went well and what went wrong. And that's not in a book.
Yes, sir.
Now, what happens is today, this question comes to us very often because we say that mediation is confidential. So, a person who passes out from college is never going to have the scope unless you are in Italy, where co-mediation is mandatory and you are required to take a junior mediator who is otherwise. Out here, there is no scope for co-mediation. So a newcomer gets no experience in a mediation room. So you don't see, you only read books.
Okay.
And mediation is a gut skill. You must know what it means, because often people are speaking one thing, but they're actually in their mind something else. You have to be able to get it out. So it requires a certain amount of skill to be developed.
Yes.
So how do young students get it? This is a question that I am asked very often in the length and breadth, not only in India but out. And my answer to them is attend competitions. Because in competitions, there is two things. One, as students, you participate, you see, you get the experience. And two, as professionals, you get to observe. These are the two places that you can build up your gut experience. And you can test it in your feedback. Is it correct? Is it wrong? Is it not? You're listening. And the other thing is books. Now, learning about mediation today in India is not a big issue because today UGC has made it an accepted subject and there's a grant and it's being taught in colleges. What I urge students is to read the experience of mediators.
Yeah.
Because what Claude has done for 25 years, in his book you will be able to read it in 2 hours, 3 hours, 4 hours or in a day. So you will be able to get that experience quick.
That knowledge,
Yes.
not that experience.
The knowledge of that experience.
Yeah, you mentioned feelings, and that reminds me of a book which is very important, very well made, and very easy to read. It's Inside Out by Gary Friedman.
Inside out.
That is the secret to leverage your own feelings vis-a-vis the parties and communicate with them.
I read a book on influence. It's a psychology book, and I find that how to persuade a person. Persuasion is another art, and it's a part of negotiation.
So it's part of law advocacy. I need to persuade a judge to accept my case.
Yeah.
So to the list of books Claude has mentioned, I'm a fan of all of them. And I would add only one more, Getting Past No. And I think put together the four actually make a Bible for any mediator to read. That said, if you call me for a training today, and if sir calls me for a training tomorrow, and you give me the same topics, it is going to be different in both cases. Because in the day span, I might have experienced another matter to talk about, which changes my perspective on how to go about it, right? And how to tell it to students. So essentially, going to trainings and asking for training material is a very, very small part of it. It's the experience that we have been harping about, which actually makes the length and breadth.
I don't think it's something very different from others, even in practice.
See, as practice-
the
as
experience
practice-
is.
No, as practice, see, there are 5 years in college.
Yeah,
Thereafter, so many years in internship.
yeah.
Then as a junior.
So you have an opportunity
You
of.
have and finally, you have the law that helps you to make amendment if your pleadings are bad.
Oh yeah.
It helps you to get an appeal
Appeal.
if you have not succeeded. Review, revision,
Yes.
and curated petitions today. which is
You
something
you
that
are
has suddenly
permitted to
come
be
up.
wrong.
Yes. Whereas in mediation, you don't have that luxury.
Okay. Yeah.
It's over. There's no appeal. There's no second chance. There's no review. If you miss the opportunity to get those two people who are entrenched to be able to get over it, the mediation is over.
And then the party's chance of reconciliation is almost over because
As good as, very
good
rarely
as-
do they come
yeah.
back for a second round.
Can I add one book to our list?
Yeah, please.
By my very close, unfortunately late friend Thierry Garby. It's
Both
called
Thierrys.
Agreed. Agreed,
Agreed.
by Thierry Garby. That's probably the Bible of mediation.
Is it possible for us to keep all these books on our description? Yeah. Because this I think that would be great.
And MCPC, the Mediation Council Project Committee of Supreme Court, actually has a consolidated
No, they have a handbook on mediation training.
Training, yeah.
They have a handbook on mediation training.
It is also very well put together and actually relies on all these books put together. So you would get a little bit of every book in there in case you're pressed for time and you're looking for something like a quick read.
But I think your library has Sriram Panchu's.
Yeah, we have. Yeah. But
I
the
don't think
blue
it's-
one, green
Yeah,
one
the
we have.
blue one. The green one is the
Yeah,
new one.
yeah.
It's come out 2 years back, but I don't think it's being taken very often.
I have one book on my night table that was written by one of the two judges I mentioned who started mediation 15 years ago, which I'm going to give Prachi today or tomorrow so that her friend Anviksha may translate it into Hindu.
Yeah.
Hindi, sorry. Hindi.
By the way, we
have a book in
mentioned the
Hindi, yeah?
concept of psychology.
Oh, on mediation.
Yeah.
You'll have
so
a
I do
second
want to
one.
mention that it is a very
No, we have done by the
advanced
EMW.
form of mediation
Push.
to
Push
have
Gupta?
a
Yeah.
psychology
I'm part of that group.
aspect involved in
Oh, I have it on my desk
Which
And
one?
in our
The Hindi one?
in English. She
No,
gave it to me in October.
That's different. Those
Okay.
are all the writing. Compendium. You have the compendium.
Yes,
We have Madhyasthan.
maybe.
Madhyasthan is the Hindi word for mediation.
Mediation, yeah.
That's done.
Yeah, you were mentioning about psychology.
So, with respect to psychology and with respect to co-mediation, sir, you mentioned psychology, sir mentioned co-mediation. Actually, 80% of my cases are co-mediated. And the reason for that is there are several aspects to a mediation which I as a lawyer cannot solve. Right? And that said, we do have on our panel trained psychologists. They are trained with children, they're trained with adults. So the different aspects of their training as well. And they do come in to co-mediate with us. And this is something I inform the parties in the beginning. That if I feel that the mediation in this room is going to go into a way where we need to deal with, let's say, your egos first, before we can deal with the numbers. Like they say, until you went, you can't negotiate, right? So we do bring in those aspects. I do also heavily rely on financial experts as and when required, or technical experts. So my mediation keeps going in and out of a single person mediating versus a co-mediation, then back to a single mediation, then when we need a financial expert, that steps in. So the mediation, the way it's done in our practice is very, very different from what it's traditionally understood to be.
Yeah. This is quite different procedure where we take the assistance of the experts in the specific
The
area.
expert is expert coming and stating. What Prachi means is they come along with
Along
you
with you.
Yes,
and work together.
yes.
100% of my mediations are co-mediation.
Yeah.
Because
So-
four ears are better than two.
It's the only way to get through to success with respect to changing the perspectives on how, see, if I have circumstances A, they might be very dire for me, but they might be very pleasant for Claude. So for me as a mediator to understand how to change my own perspective on it, I can't do it as a lawyer. It's absolutely almost impossible for me. I can persuade someone, I can push someone, but I can't change it. And for that reason, you need experts. To give you an example, we had a matter which started as a dispute between two siblings for the property they wanted to divide, which was an FMCG company. Now in India, most of the family disputes are actually hidden commercial disputes, right? Because you're dividing these large chunks of companies and properties in pre-litigation mediation, especially which come. The brother who wanted out is valuing the company at 100 crores. The brother who wants him out is valuing the company at 10 crores. So at some point, I'm not going to be able to persuade them. I'm going to have to bring in an evaluator.
Yes.
I'm going to have to bring in a psychologist. But that said, they both addressed each other only with the word Bhai Sahab in the room. You know, not even once I was very impressed did any other word come. But their egos were tall. So when you are dealing with matters like this, as a lawyer, as an architect, I feel that you need help of other parties to co-mediate. And that's the reason at least I believe strongly that co-mediation is the only way to successfully resolve the dispute.
This is one risk which I want to talk with you. As a lawyer, the moment you mediate between the parties, you are barred from representing them in any other proceedings. So you lose them forever as a client. And
You are never your client as a mediator.
yeah. But they hired your services.
They can hire me again. And in fact, under the new Mediation Act, just like the Arbitration Act they have taken the orange book and green chapters of the IBA, that you have to disclose how many mediations you have done with party X and with party Y. So that is there to show that whether you are being constantly called by this person and therefore the likelihood of a bias. So this requirement is there in the new Mediation Act.
We have the same in France. As far as repeating mediations are concerned, however, I cannot be a consultant of one of the company for a period of 2 years.
For a period of 2 years. So now the last two questions I have. One thing which I personally feel is law institutions, law colleges and national law schools, different law schools, they are not being much utilized in the mediation area. Is there any plan of action that could be proposed by you so that it can reach the right person? That how can we utilize, because we have 1,300 law schools in India, and you find them in every district places, every taluka, most of the taluka places. So penetration is there to the last man standing in the society. How do you use this penetration to propagate this mediation?
Let me tell you one thing. You all in colleges have got what is known legal aid clinics.
Yes.
I am totally opposed to it, but I have seen it with my kids being on the clinic, and I warned my daughter, especially she was very enthusiastic, don't do it because you are not skilled and you are taking a risk of giving wrong information by little information. Knowledge.
Okay.
This is something that you should keep. Having said that, the West is today moving towards what is known as peer mediation. Peer mediation is mediation within the inmates of the school of disputes that need not be within the school, of disputes that can be outside the school, where a teacher sees that a child is coming to school but is not paying attention and there is something, and they have a psychologist, which is mandatory now under the Apex Code directions. And if we find that there is a problem that the child is having with the parents and that's affecting the grades, the peer mediation concept is to call the parents and try to work a communication link. So this is something that I'm trying to get to come in as peer mediation. This is something that will build both negotiation skills, understanding skills, collaborative concepts, we can get developed.
Ms. Claude, you have any suggestions?
I think rather than law schools are doing their work. The ones that are not doing their work are business schools.
Okay.
If you look at a big company, the CEO doesn't care about conflict. He has a legal department who's paid to take care of that. Look at a small company where the CEO is at the same time the CEO, the legal director, the janitor, the salesperson,
Yeah.
the secretary. His time is precious.
Yeah.
And what we have not talked about is the advantage of mediation vis-à-vis time. I keep saying in France, every time I call to the High Court or the Court of Appeal to give a speech about mediation, I start with this. 6 hours or 6 years, what will you choose? And that's so obvious that nobody says it and everybody has forgotten. Business school do not teach mediation. I was very surprised when my second daughter went to Boston for college. She went for communication and marketing. And during the entire summer, before she joined school, I say, please read Getting to Yes. Please read Getting to Yes. Have you read Getting to Yes tomorrow? Have you read I'll read it in the plane. She read it in the plane. She arrived in Boston. 2 days fixing her room, everything. She goes into class. First teacher, first question. Who in the room has read the Getting to Yes? We don't have that in Europe. Nobody knows about negotiation. And that is the business of the law school. They're doing it. It should be the business of business schools.
Yes, Prachi.
I completely agree. We are belting out a generation of people who are thrown into this negotiation revolution which we talked about earlier, but they have no idea how to go about it. One thing that law schools can do, and I know some have already done, is to have peer mediation clinics to resolve disputes within. And there are so many disputes which come up within the students themselves, right? I mean, even if we don't look at outside disputes, even if they feel they don't have the jurisdiction to call the parents or to influence them enough to come, at least smaller disputes within the campuses should be getting resolved. It teaches a whole generation how to resolve your own disputes.
Last question. As a panelist, do you allow any enthusiast, a new enthusiast, fresh graduate, to contact you and ask for guidance
Of course,
in the
yes.
area of mediation?
Of course, yes.
I am regularly contacted, but Claude has been very, very mild and he doesn't like the spotlight on himself. But he runs an organization that helps young mediators. Why am I? So there is an organization, YMI, Angela heads it, Claude is
Eberholz.
on it, Angela Eberholz heads it, which is YMI. It's for young people who want to do mediation. It's a think group, a self-help group that can help them to get and cross over.
So I hope you don't mind if you share your emails in the description so that people may contact you.
I have no problem. My thing is over. People just go around and find my email.
You know what?
There should be some concrete outcome of this effort.
Just look at my LinkedIn page and count the number of Indian students.
So thank you very much. It's been interesting discussing with you all. It's a great experience, and this is Mediation Musings of Lex Infinitum 2025. Thank you all.
Thank you very much.
Thank you very much.